Good morning. Today is Thursday, August 28th, 2025. Let me ask you a question. Imagine that you are a lawyer. You are a prosecutor, and there is a man on trial for murder, and you are prosecuting this man for murder. And you need to decide what strategy to use to convince the jury that this man is guilty. What evidence should you show to prove your case? And you have two choices. Either you have an eyewitness who identified the defendant as the one who committed the murder, or you have DNA evidence that connects the defendant to the weapon and to the victim. But you have to choose one strategy. This is theoretical. You have to choose one strategy. Either you go with the eyewitness or you go with the DNA that proves that this is the guy who did it. Now, if you happen to be a lawyer, please don't answer that question. But think about it for a moment. It would seem that the answer, at least in Jewish law, is clear. And this is a verse in this week's Torah portion, the Parsha of Shoftim, where the Torah says, Al pi shnayim edim, o shlosha edim, yumas. The only way to convict someone of a capital crime like murder and to be able to execute that person for committing the capital crime of murder is when there are at least two eyewitnesses. And that is the case in Jewish criminal law, that a court can convict for a crime like murder or any other capital crime only on the basis of eyewitness testimony. I saw it happen, and he's the one who did it. There is no circumstantial evidence permitted. Even DNA evidence is not permitted in a case of criminal law in Jewish law. But if that's correct, how do we explain the following? This is from an article written in the New York Times by Adam Liptak from 2007. In April, Jerry Miller, an Illinois man who served 24 years for a rape he did not commit, became the 200th American prisoner cleared by DNA evidence. His case, like the 199 others, represented a catastrophic failure in the criminal justice system. So, again, in 2007, you had 200 people in the United States who had been convicted of serious crimes and put in prison, but was then found to be innocent. They did not commit the crime. Okay, well, that's terrible to begin with. But listen to this. Brandon Garrett is a law professor at the University of Virginia. And he examined those 200 cases. And the 200 cases in which innocent people served an average of 12 years in prison, average of 12 years in prison, and then it was proven beyond a shadow of a doubt that they were innocent. So he studied these 200, and listen to this. The leading cause of the wrongful convictions was erroneous identification by eyewitnesses, which occurred 79% of the time. 79% of these innocent people were found guilty because of eyewitness testimony. Here's another article by Adam Liptak, this one written in 2011. Every year, this is in the United States, every year, more than 75,000 eyewitnesses identify suspects in criminal investigations. Those identifications are wrong about a third of the time. What they collectively show is that it is perilous to base a conviction on a witness's identification of a stranger. Memory is not a videotape. It is fragile at best, worse under stress, and subject to distortion and contamination. And the unreliability of eyewitness identification is matched by its power. There's a quote from U.S. Supreme Court Justice William Brennan. There is almost nothing more convincing than a live human being who takes the stand, points the finger at the defendant, and says, "That's the one." But the problem is, it's often wrong. And if it is often wrong, so often wrong, why does the Torah rely on it exclusively? So this question is answered by a difference in the definition of eyewitness testimony. Because in secular courts, eyewitness testimony can be a person who was a victim of a crime or who was near watching the crime. So that means that that person was under tremendous stress when they were witnessing it. That person who is testifying could very well have already been convicted themselves of other offenses and is testifying in the hope of leniency or some other perceived benefit as a result of their testimony. And also the way that witnesses are asked to identify a defendant is often done in ways that evidence has shown, research has shown, do not lead to accurate results. In Jewish law, the definition of eyewitness testimony is very, very different. Number one, in order to convict, there must be two eyewitnesses. They must have no connection to either the victim or the defendant. They must be known as moral, honest people, gaining no benefit whatsoever from their testimony. And also, and this is the real kicker, before the crime, they must speak to the perpetrator, the potential perpetrator, warn that person before he or she commits the crime and say to him, "Don't do that, because if you do that, this is going to be the punishment." And the perpetrator has to acknowledge that he heard the warning. "I heard what you said, va'af al pikein, and nevertheless, I'm going to kill this person," God forbid. That's what the Torah means by eyewitness testimony. And as you can see, there are numerous built-in strengths to make sure that that is accurate. In person, with interaction with the perpetrator, up close, by people who are known to be honest and have nothing to gain, no motive to lie, and no pressure from anyone to testify. As I mentioned before, in courts today, witnesses often have reason to lie. Either they have a connection to either the victim or the defendant. They, as I said, they may be a criminal themselves. They may have been a promise of preferential treatment or an implied promise of preferential treatment. Or when they are shown photos, they are shown the photos with subtle cues and body language suggesting who to pick. For example, most identifications in police departments have a group of photos. Let's say there are 12 photos of different people, and they show all 12 photos at once, show us which one did the murder. Now, experts who research this say that this is unreliable because the police have created the impression that the murderer is there somewhere, and the witness is subconsciously pressured to choose one of them. The preferable way to do it, based on research, is to show one photo at a time and to say the murderer may not be in this group at all. Also, experts say the officers who are investigating the case should not oversee the identification, as they also may subtly influence the identification of the witness. But when all of these precautions are in place, then eyewitness testimony is in fact very accurate, as the Torah indicates. But the way that it is actually practiced in secular law in the United States, in Canada, and other places is very inaccurate because memory and perception are not perfect. And especially because if a person is watching something and they themselves are under stress, their memory is much more likely to be imperfect. Now, we do not practice Jewish criminal law today. That only applies when the Beit HaMikdash is standing and the Sanhedrin HaGadol, the great Sanhedrin, is sitting in the courthouse in Jerusalem. So this rule is not practically applicable to us. But there is a crucial lesson that is relevant to every one of us every day. Because it so often happens, think to yourself how often this happens in your life, in your day. It so often happens that we are sure of something. This could be in any area of life. Something we remember, something we see, something we hear. I'm sure I left my keys on this table. I'm sure I remember what happened at that birthday party. I'm sure that so-and-so said such and such. I'm positive. And sometimes, not just sometimes, we are wrong. As I said to you before, memory is not a videotape. Now, I'm not talking about a situation of a matter of principle, and I say one thing and others disagree. I stand up for the principle. Doesn't matter if it's popular. And I'm not talking about a situation where you reach a conclusion about what you remember, and then you check yourself, and you consider the alternatives, and then you stay firm with the memory, because sometimes I actually did put my keys there. But when you come to an immediate conclusion about what you saw or heard or remember, consider always the possibility that you may be wrong, because experts tell us that that is very common. The novelist Walter Mosely says through one of his characters that one of the most important lessons in life is to realize everybody knows things I don't. Everybody sees things I've missed. So many people would be so much more pleasant to live with if they could just follow this advice. And I am absolutely certain that this is true. My friends, I wish you a great day, and I look forward to seeing you soon in person.